Sumipot si Vice President Sara Duterte sa kanyang impeachment hearing sa Kamara, habang ang ilang kongresista naman tila nang asar pa. Nagbaon kasi sila ng chichirya na patama sa controversial na Mary Grace Piattos. Narito ang buong detalye. Ngunit bago tayo magpatuloy, huwag kalimutang i-like, share, subscribe, and click the notification bell for more updates and for more upcoming videos. Maraming salamat! May pwesto, may nameplate at upuan ng House Justice Committee para kay Vice President Sara Duterte, pero no show ang busy sa kanyang impeachment hearing. Nagpadala lang ng sulat ang legal counsel ni VP Sara na Fortuner Basa and Salazar Law. Dito pinuna ng kampo ng bise ang sinabi ni chairwoman ng komite na si Congresswoman Jinky Luestro na maituturing daw na mini trial ang pagdinig ng Kamara. Unconstitutional o labag daw sa saligang batas yan. Senado lang daw kasi ang maaaring tumayong impeachment court.
We believe that the committee really has no jurisdiction to conduct any form of trial. There was no disrespect intended because in fact, we had responded to the invitation.
Sa pahayag pa ng bise, pinababasura niya ang mga reklamo dahil kulang daw ang ebidensya. Buwelta naman ng mga miyembro ng House Justice Committee. Ironious sumali ang anilay palusot ng kampo ni VP Sara. Malinaw sa saligang batas at sa House Rules and Impeachment na may mandato ang komite na magsagawa ng pagdinig. Sa Article 11 Section 3.2 ng Konstitusyon, nakasaad na matapos ang hearing ng komite at botohan ng mayorya ng mga miyembro nito, kailangang isumite ang komite report sa loob ng 60 session days.
Some members of the Justice Committee is intended only to make a distinction between the proceeding before the Justice Committee and the trial which will happen in the Senate. We are not holding trial. This is just a clarificatory hearing for the purpose of determining probable cause which will allow us to proceed to trial in the Senate.
The particular position of the councils and of the Vice President herself is basically a legal word salad. Ibig sabihin po, wala po itong batayan sa katotohanan. Ito po ay legal na pagpapalusot.
Pinasasabi na pa ng komite ang ilang testigo na kakailanganin sa paggulong ng impeachment hearing. Kabilang dyan ang umano'y bagman ni VP Sara na si Ramil Madriaga. Pati si Attorney Gloria Camora ng Commission on Audit Intelligence and Confidential Funds Audit Office. Pinatatawag din si Attorney Michael Powa na dating Chief of Staff at spokesperson ni VP Sara sa DepEd of Education. Yan ay kahit kasama si Powa sa listahan ng mga tatayong abogado ng bise sa impeachment. Sagot ni Powa.
I will wait for the subpoena. Titingnan ko kung ano yung laman ng subpoena, but definitely I'm willing to attend. No, wala akong any intention to evade. But I will go there as a resource person or witness, whatever they want to qualify or characterize it as such. And I will answer the questions as the best way I know how based on my personal knowledge.
Pinasasabi na rin ng komite ang mga dokumento sa Philippine Statistic Authority kaugnay sa mga taong tumanggap umano ng acknowledgement receipt ng DepEd at OVP. Kabilang na ang controversial na si Mary Grace Piattos. Tila may pasaring pangarya ng ilang kongresista na ibinalandra ang kanilang baong pagkain. Hiniling rin ng NBI ang record sa investigasyon sa pagbabanta ni Vice President Sara Duterte sa buhay ni Pangulong Bongbong Marcos, First Lady Liza Araneta Marcos at dating House Speaker Martin Romualdez. Inaprubahan rin ang motion ni Akbayan Party List Representative Shell Jokno para sa protective custody ni Madriaga.
Madam Chair.
The Honorable Zamora.
As this is a continuation of the hearing held on March 18, 2026, I move to dispense with the calling of the roll.
There is a motion to dispense with the calling of the roll. Do I hear a second?
Second, Madam Chair.
Is there any objection? Hearing none, the motion to dispense with the calling of the roll is hereby granted. Can I hear a motion on the reading of the minutes and its approval?
Madam Chair, I move to dispense with the reading of the minutes held last meeting, and I move for its approval.
There's a motion to dispense with the reading of the minutes of the last meeting and for its approval. Do I hear a second? Second. Is there any objection? Hearing none, the motion is approved. The reading of the minutes is dispensed with and the same is approved. The Chair will address the Justice Committee. Magandang umaga po sa inyong lahat. Sa aking mga kapwa miyembro ng kapulungan, sa ating mga panauhin na naririto ngayon at sa sambayanang Pilipino. Before we begin, at bago natin ipagpatuloy itong proseso ng impeachment, tandaan natin na hindi lingid sa ating kaalaman na marami pa tayong ibang kinakaharap na problema. Let us accordingly acknowledge the pressing challenges our country faces. Oil prices are rising. The cost of basic goods is increasing. Ordinary Filipinos feel the weight of daily life more than ever. And yet, even as we undertake this solemn constitutional duty, the House of Representatives does not forget its other responsibilities. Kahit may impeachment, tuloy pa rin tayo sa iba nating obligasyon. We have, for example, acted to ease the burden of rising fuel costs, passing a bill authorizing the suspension or reduction of excise taxes. Nariyan na po ang panukalang batas, pinag-aralan, pinag-isipan, at inaasahang makatutulong sa ating mga kababayan. We also continue to work on measures that address inflation, food security, and social services. Also, just this March 2026, the House has acted on measures that directly affect the daily lives of Filipinos, passing a bill abolishing the travel tax, advancing legislation to institutionalize digital payments in government transactions, and pushing reforms to make public services more accessible and efficient. The House has also advanced key education reforms, including amendments to the Universal Access to Quality Tertiary Education Act and the Presidential Merit Scholarship Program. This strengthens support for students and investing as well in the country's future workforce. And after nationwide consultations across Luzon, Visayas, and Mindanao, the House has pushed forward the long-awaited anti-political dynasty bill with plenary deliberations recently completed. These actions remind us that governance is a constant balancing act, attending to urgent needs while fulfilling constitutional obligations. Kahit may impeachment, tuloy tayo sa iba nating tungkulin. Ang ating serbisyo publiko ay hindi napuputol, hindi tumitigil kahit sa gitna ng pinakamabigat na tungkulin. While we scrutinize those in power, we do not lose sight of the hardships faced by the powerless. Having said that, we proceed today fully aware of our dual duty to hold public officials accountable and to serve the people who entrusted us with this mandate. And so now, we begin. Dito nagsisimula ang opisyal na pagdinig ng kasong ito. Sa ating pagsisimula, tandaan natin na ang impeachment ay patungkol sa pananagutan sa bayan. Kaya't marapat lamang na balikan natin ang ating panunumpa. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Madaling bigkasin, pero mahirap panindigan. Hindi ito simpleng ritual. Ito ay isang pangako, isang panata ng pananagutan, hindi lamang sa batas, kung hindi sa bayan. Let me lay out the agenda for today. First, we establish the ground rules or the guidelines, not as obstacles, but as safeguards. Their purpose is simple: to maintain order, to allow clarity, so that truth may emerge unimpeded. Ang patakaran ay hindi hadlang sa katotohanan. Ito ang daan upang ito'y malinaw na lumitaw. Second, we move to the initial hearing. Opisyal po nating buksan ang pagdinig sa impeachment na ito. Third, and as part of this initial hearing, we act on pending motions, request for subpoenas, and set the schedule for the next hearings. At the core of these proceedings is probable cause. That is the objective of these hearings. We shall determine whether there is probable cause for impeachment. Ngunit, paano ba natin masasabi na merong probable cause? Let us be clear. This is not the probable cause of criminal procedure. Impeachment is not a criminal trial. It is a constitutional and policy exercise entrusted not to the courts, but to the House of Representatives. As we have seen in previous proceedings against Ombudsman Mercedes Gutierrez, the classical legal definition of probable cause was not applied. And for good reason. Impeachment calls for judgment, not mere calculation. It asks not only what can be proven, but what can be justified before the people. As the late Father Joaquin Berna said, impeachment is about what is best for the country. Hindi lang ito tanong ng kung ano ang nasa batas. Ito rin ay tanong ng kapakanan ng bayan. Consider the ground of betrayal of public trust. What does it mean? Can it be reduced to a single act? A measurable threshold? Or is it something more? Something felt as much as it is proven? Paano mo susukatin ang pagtataksil sa tiwala? Sa bilang ba ng ebidensya o sa bigat ng paglabag? We are confronted with serious allegations, threats against the President, accumulation of ill-gotten wealth, SALN violations, misuse of confidential funds, disregard of safeguards for transparency, and defiance of constitutional process. These are not trivial matters. They go to the very heart of public trust. May mga kasalanang hindi kailangang ipaliwanag, ramdam agad ng taong bayan. The truth is, betrayal of public trust resists rigid definition. And if the standard is not mechanical, neither can the threshold to examine it be mechanical. Kung ang batayan ay may bahid ng moralidad, ang paghusga ay hindi maiiwasan dumaan sa konsensya. Conscience becomes our guide, not as a substitute for evidence, but as its interpreter. Evidence tells us what happened. Conscience tells us what it means. Ang batas ang nagbibigay ng balangkas. Ang konsensya ang magbibigay ng kahulugan. Therefore, to determine probable cause is to listen, to weigh, and to decide, not by rigid formulas alone, but by what is just and right for the Filipino people. Ngunit malinaw sa atin, ang araw na ito ay simula pa lamang. Sa mga darating na linggo, sa mga susunod na pagdinig, hihimayin natin ang mga aligasyon isa-isa. Susuriin ang bawat ebidensya. Magtatawag tayo ng mga testigo. Pakikinggan ang bawat argumento at titimbangin ang depensa. Today is just the beginning of a process that demands patience, discipline, and vigilance. At sa prosesong ito, sisikapin nating maging tapat, hindi lamang sa batas, kundi sa sambayanang Pilipino. And in the search for probable cause, let us remember that what we are conducting here is merely investigative in nature, where the question is not guilt, but whether there is sufficient basis to proceed to trial in the Senate. At this stage, in this committee, there is no deprivation. No one is being removed from office here. No one is being disqualified. No final judgment is being rendered. Those consequences, if they are to come at all, arise only in the Senate, where the trial is held, where the evidence is fully ventilated, and where the full measure of due process applies. But this is not to say that due process is absent here. Far from it. We have to remember that whatever we do here in the committee must always be in accordance with the Constitution, particularly the demands of due process. The Vice President has been invited to participate. She is reportedly prepared for a full-scale legal battle, a bloodbath, as it has been described, assembling a very large team of lawyers. She is apparently ready to face the accusations and defend herself at length. And yet it appears she will not even participate. We recall the words of Justice Antonio Tiham in the previous impeachment against Chief Justice Maria Lourdes Sireno. Failure to participate in the hearings before the Committee on Justice is tantamount to a culpable violation of the Constitution. Ayon sa pananaw na iyon, ang hindi pagharap sa proseso ay maaaring ituring na patuloy na paglabag sa saligang batas. Ang tanong ngayon, maaari rin ba nating sabihin ito sa Vice Presidente? Let us remember, the Vice President took the same oath. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Lahat ho ng kawani ng gobyerno, lahat ng opisyal ng pamahalaan, iisa ang panunumpa. Iisa ang pamantayan. Iisa ang pananagutan. Ang panunumpang ito ay hindi lamang pangako ng panunungkulan. Ito ay panata ng pagharap sa pananagutan at paggalang sa saligang batas. Dito sa komite, susundan natin ang saligang batas. Hindi natin tatalikuran ang ating tungkulin. Iyan ang inaasahan ng taong bayan. Hindi pag-iwas, kundi pagharap. Hindi katahimikan, kundi pananagutan. Sapagkat ang panunumpa ay hindi lamang binibigkas sa simula. Ito ay pinatutunayan sa bawat pagkakataon na tayo ay sinusubok. So regardless of the participation of the Vice President, and even in her absence, this committee will proceed. We will do our duty with resolve, without hesitation, and without delay. The Constitution entrusts the House with the exclusive power to initiate impeachment cases, and this committee stands at the forefront of that responsibility. Tayo lamang, ang Committee on Justice lamang, ang tahasang binigyan ng ganitong tungkulin sa saligang batas. In the end, this is not merely a procedural exercise. This is a test of judgment, of conscience, and of courage. Let us proceed with diligence, with fairness, with honesty, knowing that our actions today will echo far beyond this chamber. And so we return to where we began. Sa huli, babalik tayo sa ating panunumpa. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Madaling bigkasin, pero mahirap panindigan. Ang tanong, para sa lahat ng kawani ng gobyerno, para sa lahat ng opisyal ng pamahalaan, para sa vice-presidente, tinutupad ba natin ito? Pinaninindigan ba natin ito? Iyan ang tanong na sisimulan nating sagutin dito sa impeachment na ito. Maraming salamat po. We now call the case. Committee Secretary.
Thank you, Your Honor. Initial hearing on the impeachment complaints against Vice President Sara Duterte, filed by Reverend Father Joel Saballa et al. And endorsed by Representative Laila M. De Lima, and filed by Attorney Nathaniel G. Cabrera, and endorsed by Representatives Bienvenido M. Abante Jr. and Francisco Paulo P. Ortega V.
Madam Chair,
The Honorable Jokno.
may I be allowed to make a brief manifestation
Which manifestation?
in relation to the opening statement?
The opening statement.
made by
You may
the
proceed,
Chair.
the Honorable Jokno.
Thank you, Madam Chair, distinguished colleagues, mga kababayan natin nanonood, at magandang umaga po sa atin lahat. Marami po nagtatanong, ano ba talaga itong impeachment at ano ba ang proseso sa impeachment? Klarong-klaro po sa ating konstitusyon, Article 11, Section 3, the House of Representatives has the exclusive power to initiate all cases of impeachment, while the Senate has the sole power to try and decide all cases of impeachment. Sa madaling salita, ang Kongreso ang nagsasampa o naghahain ng impeachment case, habang ang Senado naman ang nagsisilbing hukom o tagahatol. Kaya tayo nandito sa hearing na ito ay para malaman, dapat nga bang isampa ang impeachment case laban sa Vice Presidente? Nung nakaraan, nakita po natin na sufficient in form and substance ang dalawang impeachment complaint. Ibig sabihin nito, sapat o tama ang forma ng mga reklamo at may sapat na nilalaman para umusad tayo sa pagdinig na ito. Nakita din ng committee na ang impeachment complaint ay sufficient in grounds o may sapat na batayan. Sa puntong ito, mismo ang konstitusyon ang nag-uutos sa Committee on Justice na magsagawa ng hearing. Ano naman ang ihihiring natin? Siyempre, walang iba kundi ang ebidensya at testigo. Our duty is clear, Madam Chair. This committee must secure and verify every piece of evidence, and we must protect every witness so they may give their testimony under oath. Ito ay naaayon mismo sa Section 7 at 8 ng Rules of Impeachment. Ito ang dahilan kung bakit po tayo naghain ng motion para makuha ang kopya ng SALN ng Vice Presidente at para bigyan ng proteksyon ang testigo na si Mr. Ramil Madriaga. Ang impeachment case na ito ay dadaan sa butas ng karayom. This is the only way for the truth to come out. Pagkatapos ng committee, boboto po ang buong Kamara at magpapasya kung dapat ilitis ang kaso sa Senado. At sa bawat hakbang, nakatutok ang buong bansa para bantayan ang proseso. Maraming salamat po. Thank you, Madam Chair.
The manifestation of the Honorable Jokno is noted by the committee.
Madam Chair.
The Honorable De Lima.
Also a brief manifestation and a question to the Honorable Chair and the Committee
With the indulgence
Secretariat.
of the Honorable De Lima, we would like to tackle first our ground rules before we proceed to your subsequent manifestations and questions to the committee.
Thank you, Madam Chair. Thank you.
Madam Chair.
Regarding the ground rules, we would like to acknowledge Vice Chair Zamora.
Thank you, Madam Chair. Bago po tayo magsimula sa deliberasyon ukol sa pagtukoy ng probable cause sa impeachment proceedings na ito, kinakailangan magtakda ng ating chairperson ng ilang panuntunan upang matiyak ang maayos, patas at episyenteng pagtatalakay. Ang komite ay may 38 na regular members. Ang quorum ay 1/5 ng kabuuan. Ang ex-officio members ay may boses at may boto. Ang mga nais magsalita ay kailangan makipag-ugnayan sa committee secretary upang maitala ang kanilang pangalan. Magkakaroon tayo ng alternating recognition ng minority at majority na may 5 minuto bawat isa. Maaari tayong magbigay ng second round kung may oras pa po. Hinihiling ng chairperson na hintayin muna ang kanyang pagkilala bago magsalita upang mapanatili ang kaayusan. Sa mismong pagdinig, ang mga resource persons ay susuriin ng mga miyembro ng komite alinsunod sa Section 7 of the Rules of Procedure in Impeachment Proceedings. Ang mga resource persons ay hindi papayagang magsalita o gumawa ng mga interjection malibang kung at hanggang sa sila ay kilalanin ng ating chairperson. Tanging ang mga miyembro ng komite lamang ang may karapatang suriin o i-cross-examine ang mga resource persons. Ang mga partido ay maaaring humingi ng pahintulot mula sa chairperson na magsumite ng mga tanong na itatanong ng ating chairperson kung sa kanyang opinyon ay kinakailangan ang mga ito para maging malinaw ang talakayan. Ang pakikilahok ng mga abogado ng mga partido o resource persons ay limitado sa pagpapayo sa kanilang mga kliyente tungkol sa kanilang mga karapatan sa ilalim ng konstitusyon. Dapat silang sumunod sa wastong kagandahang asal at hindi sila papayagang magsalita o gumawa ng mga interjection malibang kung at hanggang sa sila ay kausapin o kilalanin ng chairperson. Mga kasama, impeachment is an extraordinary constitutional process. It demands sobriety, discipline, and unwavering respect for the rule of law. Hindi personalidad ang ating hinaharap ngayon, kundi ang ating constitutional duties. Thank you very much, Madam Chair.
Can we hear the necessary motion for the adoption of ground rules?
Madam Chair, I move to adopt the ground rules as stated earlier.
There is a motion to adopt the ground rules read by the Honorable Zamora. Do I hear a second?
Madam Chair,
Is there any objection?
discussion. Madam
The Honorable Rodriguez.
Madam Chair, the right to counsel is assured by the Constitution. So therefore, the respondent here has always have the right to counsel. In fact, in many cases, our rules of court is suppletory to the rules of impeachment in the House. And so therefore, this representation believes that first, they are entitled, counsels for both sides are entitled to send questions, and I agree with that, Madam Chair. But what I would like to emphasize is that the Vice President can always designate their counsel to appear in all the proceedings, so that we should be able to state there that the right to counsel, the right to be heard by herself or counsel is assured by the Constitution. But we know the response of the proponent of the motion as to that particular observation.
If I may confirm, the Honorable Rodriguez, you would like the committee to acknowledge the right of the counsel even in the absence of the respondent.
That's correct. Based on jurisprudence, Madam Chair, that although this is not a criminal proceeding, it is akin to a criminal case because we are trying to remove and there is also perpetual disqualification. And so, in other words, the Vice President can send her counsels here to appear for her. In fact, the right to self-incrimination is there. And a person who is now being investigated has the right to already not take the stand or at the time she wants to appear to be able to invoke it when she is asked an incriminatory question. So that is the position of this counsel. Thank you, Madam Chair.
Of course, based on the ground rules that was read by the Honorable Zamora, the right to counsel is described as assistance to clients or to the parties. Now it is being proposed by the Honorable Rodriguez that the same be acknowledged even in the absence of the respondent or the parties. May I hear the comment of the members of the Justice Committee?
Madam Chair.
The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I agree if that is on the presentation of the complaint's evidence. But at the time the respondent will be presenting her evidence, she must be present because who will answer clarificatory questions in cross-examinations of what will be presented? She is the only one. The counsels are not witnesses in this particular case. So I hope my colleague will agree that at the time the respondent is given the opportunity to present her evidence, she must be present. Thank you, Madam Chair.
Would you like to clarify the extent of the participation that you are proposing?
Yes, Madam Chair. What I am proposing is, at the time that we have concluded the presentation of the evidence of the complainants, and it will be the turn of the respondents, then the respondents or her witnesses must be present because they are the only ones who can answer clarificatory questions or cross-examination questions of any of the members of this committee. The lawyers of the respondents are not witnesses to the said defense of the respondent. So it is a must, Madam Chair, that she must be present at the unless she will waive the presentation of her evidence when it is her time to present her evidence pursuant to our rules of impeachment, Madam Chair.
For purposes of accuracy, Honorable Vice Chair Dumogan, you are proposing that the respondent's counsel, even in her absence, be allowed to present the evidence. But for purposes of clarificatory hearing, it should be the Vice President herself who should be present and answer the questions before the Justice Committee.
That's exactly correct, Madam Chair.
Thank you. Any other member who
Madam
wish to
Chair.
manifest? The Honorable Rodriguez.
Madam Chair, the right against self-incrimination is very clear. Under our rules, the criminal procedure rules, which are suppletory, because our rules are very, very pithy in terms of the procedure. 2 points, Madam Chair. The respondent has the right not to appear, and therefore she does not need to be present, because that is the right of a respondent, akin to a accused in a criminal case, as decided in the cases, Madam Chair. That's number one. Number two, the counsels here are not only to advise on the legal rights, they have the right to cross-examine, because the Vice President will not be present. If she's present, she cannot cross-examine witnesses, because she has lawyers. So therefore, 2 points. The rule that requires that lawyers can only, the participation is only to advise the legal rights of the witness is on the rules on the investigation in aid of legislation. That is especially found in the rules in aid of legislation, the hearings. But it is not found in our rules. I've been reading our rules of procedure. There's nothing here that limits it to only advising. Therefore, in an adversary proceeding like this, we have to therefore hear the counsels if they wish to be present, but if not, then that is also the lookout of the respondent. But I believe that we should be clear in our rules that the presence of counsel of the respondent has the right to cross-examine directly the witnesses for the complainants. And secondly, there is no need for the Vice President to appear in hearing, because that is her right not to be able to appear, and we can make conclusions out of her non-appearance. No need for her to appear. Thank you, Madam Chair.
Madam Chair.
Madam,
The Honorable Chua, are you raising your hand?
No. Madam Chair.
The Honorable Vice Chair Dumogan.
The first part of the point had already been settled. Under our own rules, which is the subject of the motion, the counsel of the respondents are allowed to cross-examine by writing their questions, submitting it to the chair. What I am pointing out, Madam Chair, is at the time the respondent is given the opportunity to present her evidence. Well, counsel may present her evidence, but she must be present, or the witnesses that she is presenting must be present, so that the members of the committee will have the chance to examine or ask clarificatory questions from them. The counsels are not witnesses to the defense of the respondents, Madam Chair. Thank you, Madam Chair.
For the guidance of the justice members, part of the proposed rule is giving opportunity to the complainant and the respondent and their counsels to submit questions to the chairperson so that they may be raised in the deliberation if no justice members are raising similar questions. Let us all be guided as well that the hearing proper in the Justice Committee is akin to a preliminary investigation. So, let us be guided by the fact that as well, that we're trying to establish here is merely probable cause, which means a justification to be able to proceed to trial, which will definitely happen not here, but in the Senate.
Madam
The
Chair.
Honorable Chua.
Thank you, Madam Chair. Madam Chair, let me read what is provided under our rules, the rules of procedure in impeachment proceeding. Under Section 7, it provides that if the committee finds that there is sufficient ground for impeachment exists, the committee shall conduct a hearing, which we are now doing. The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. Therefore, Madam Chair, it is very clear under our rules that it is only the members of the committee who can participate with respect to the examination and cross-examination of the members. Why? Because, like what you said a while ago, this is akin to the preliminary investigation wherein it is the investigating officer or the investigating city prosecutor who is asking clarificatory questions. We are not yet in the trial where the lawyers or counsel of the defendant can cross-examine the witnesses. Now, this can also be, we can also be guided by our rules of procedure governing inquiries in aid of legislation, which the Honorable Rufus Rodriguez mentioned a while ago, that under Section 13, appearance of counsel, here, the participation of counsel for witness during the hearing and while the witness is testifying shall be limited to advising on the legal rights of said witness. Why? Because this is committee function. So, ganun din po dito. Ito pong ginagawa natin is also a committee function. The cross-examination, ang purpose po ng cross-examination dito is just to ask or just to clarify questions. Hindi pa po ito yung talagang trial proper wherein we can cross-examine thoroughly the witnesses. Thank you, Madam Chair.
Madam Chair.
Thank you. The Honorable De Lima.
Thank you, Madam Chair. I concur with the views expressed by the Honorable Joel Chua. As expressed very clearly by the Honorable Chair earlier, the proceedings today, or the proceedings from now on, henceforth, would be the determination of probable cause. And therefore, this proceedings is indeed akin to a preliminary investigation. There are no formal direct examination or cross-examination in the proceedings before the prosecutor's office. Yes, we can recognize the respondents and the complainants' right to counsel, but their role ought to be limited because this is only preliminary investigation. Role like identifying affidavits can assist their clients, can assist the complainants, or can assist the respondent. But if they have questions, as expressed and as already laid down in the ground rules read by the Honorable Representative Zamora, they can course it through the chair. In that case, they are afforded the right to confront, the right to ask clarificatory questions. This is not a full-blown trial yet that happens in the Senate. Just to repeat, this is akin to preliminary investigation, determination of probable cause. The proceedings or the hearings before the prosecutor's office, and this is the prosecutors, the Committee on Justice, is actually also limited, and no full-blown examination, whether it's direct examination or cross-examination, being conducted or held at that point. So I think it's very clear, as expressed by the Honorable Chair, and also indicated in the ground rules. We are not denying the parties their right to counsel. They have the right to counsel. They can assist for purposes especially also of asking clarificatory questions, but we have our own rules here, coursed through the Honorable Chair. Thank you.
Madam Chair.
The Honorable Ridon and then the Honorable Rodriguez.
Well, maganda po yung talakayan kanina patungkol doon sa konsepto ng karapatan sa pagkakaroon po ng abogado. But I think just for the record, meron pong sulat yung mga abogado ni Vice President Sara Duterte na wala naman po ata talaga din silang interest at this point na dumalo either ang pangalawang Pangulo o yung mga abogado po mismo. And I will read it for the record.
Madam Chair, we are still on our ground rules discussion, so that can probably wait, and we will be able to discuss that.
No,
because we are now on approving the ground rules. We are not yet determining what the Council or the Vice President is proposing or manifesting to us.
For the guidance of the Justice members, there is a pending motion for the approval of the ground rules read by the Honorable Zamora. Perhaps we will be proceeding to the letter sent by the lawyers of the respondent after we address the motion for the approval of the ground rules.
Yes, Madam Chair, but just to make the point that even if we talk about a conceptual matter relating to the right to counsel, if the counsels themselves are actually questioning these proceedings and the Vice President herself is questioning this proceeding, I think that needs to be placed on record, Madam Chair. So I will read it. For two Narvasas and Salazar.
Madam Chair.
The Honorable Ridon
That will
is
be out of order.
requested to defer the discussion on the letter of Fortuna Narvasa until we address the pending motion before the committee. So if we can go back to the motion, the
Madam
same
Chair.
has been seconded already.
Other discussion because there were interjections.
That is with regards to
the
the
rules.
ground rules.
Yes, Madam
The Honorable Rodriguez.
Madam Chair, there is here a statement that in our rules, only members can ask questions, and I would refer now to Section 7. Committee finds, and then the committee shall conduct a hearing and examination and cross-examination by members of the committee. Very clear. However, Section 7 shall obey the Constitution of the Republic of the Philippines. The Bill of Rights, Madam Chair, Article 3, provides that the right to be heard by himself or herself or to counsel is inviolable. It is in paragraph, in section, in the rules, in the Bill of Rights, is in the section on Section 2, and then also on custodial Section 2 and Section 4. So, Mr. Chairman, I am saying that we just have to give the right, otherwise there will be no due process. If only the members
Chair.
can ask, we should allow.
Madam
Can I
Chair.
finish
Chair,
first,
they
Madam
have
Chair?
the right.
I have allowed my good chair to finish, so let me finish my manifestation. So therefore, Madam Chair, it is very clear that counsels should be allowed to cross-examine. Now, the issue here is that the rules provide that they submit the questions to the chairman. Will the chairman have the discretion to read or not? Or everything that will be given to the chairman will be read?
To answer the question of the Honorable Rodriguez, so long as the question is germane to the discussion pending before the committee, the chair will read the questions which are being submitted or which will be submitted by the counsels of the parties. That includes the counsel of the respondent.
Thank you, Madam Chair. But
Madam
just to be
Chair.
able to state that this representation believes to be able to afford really procedural due process as pronounced in the leading case of Antibay versus CIR. The 7 cardinal rights of a person who is accused, in this case, akin. We are really, this is even more than a criminal case because we are trying to remove the official who had the highest votes in the history of this country as Vice President. So what I'm saying, Madam Chair, we should allow the counsels to appear if they so wish and be able to cross-examine the witnesses of the complainants. That is the way to be able to afford the opportunity of procedural due process as is enshrined in Article 1 of Article 3 of Section 1 of the Constitution.
Madam
Let
Chair.
us be guided by the fact that this is not yet the trial.
Madam Chair, may
So
I be
what
allowed?
will happen before the Justice Committee is indeed merely a clarificatory hearing. Trial is different because, as has been repeatedly stated, only the Senate can conduct the trial.
Madam
What
Chair.
will happen before us is merely clarificatory hearing, and those questions are to be raised by the justice members. Of course, the lawyers of the respondent are free to attend the hearings, but with respect to their participation, I think that has been addressed in the proposed ground rules, that their questions may be submitted to the justice chairperson, who will be reading those questions to be answered by the resource persons.
Madam
Let
Chair.
let us draw the line between the clarificatory hearing between the Justice Committee and the trial, which will happen in the event that there is probable cause in the Senate only.
Madam Chair.
The Honorable Chua.
Thank you, Madam Chair. To answer the manifestation of my professor, the Honorable Rufus Rodriguez, there is no violation of due process, Madam Chair. Why? Because the respondent was given the opportunity to answer. That was the time when she is allowed to give all her answer. Now, sinasabi po natin that this is akin to preliminary investigation. Sa preliminary investigation po ba, did we allow the complainant and the counsel to cross-examine? No. It was only the investigating prosecutor who is allowed to propound question to clarify. Hindi pa po ito yung full-blown trial. And us, as member of the Justice Committee, that is our job, to ask clarificatory questions. Yun po yung intention nito. To do otherwise, kung iba po yung nasa isip nito, dapat clearly and expressly nilagay po dito sa ating rules na yung examination and cross-examination can be conducted by members of the committee and or counsel and the complainant. Kaso hindi naman po ganun eh. Sa buong Pilipinas, wala po kayo, never po nangyari sa preliminary investigation, nagkaroon ng cross-examination or nagkaroon ng opportunity na mag-cross-examine ang counsel at ang complainant. Thank you, Madam Chair.
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable Zamora and then the Honorable Vice Chair Dumogan.
Madam Chair, I reiterate my motion to approve, to adopt the ground rules as I earlier stated.
In the interest of due process, let's hear as the last manifestation on the issue of representation by counsel, the Honorable Zamora, the Honorable Dumogan, and then we rule on the motion to approve the ground rules. Honorable Dumogan.
Thank you, Madam Chair. As I said, we fully is in the motion that respondent is entitled to counsel. In her counsel are entitled to ask clarificatory question, but it must be coursed through the chair, who will read the questions. That is the same in a preliminary investigation in a criminal case. But on the other hand, after the complainants had presented their evidence, it will now be the turn of the respondent. When the term of the respondent will come, counsel can possibly present also the evidence of the respondent. But, as I said, the respondent must be present because who will now answer clarificatory questions from the investigators? The members of the committee are considered as the fiscal conducting an investigation. So, who will now answer the clarificatory questions of this committee if the respondent will not be here? So, anyway, it will be her right if she does not appear. But to me, it will be a waiver of her right also to answer clarificatory questions of any members of this committee. respectfully submit.
Thank you. At this juncture, we shall now
Madam
resolve
Chair, Madam Chair,
the motion. I think
another-
we've heard already
No,
all
another
your meaningful and significant manifestations on the right to be represented by counsel. So with the indulgence of the
Madam
Honorable
Chair,
Zamora.
there is a next ground rule which I would like to again manifest. We're finished with the representation and
Okay.
presence.
You may proceed on the
I'd
next ground rule.
I would like to ask our Vice Chair, after the issue of the questions to be sent, what is the next ground rule? Because I have also a manifestation on that.
The last one is ang pakikilahok ng mga abogado ng mga partido o resource person ay limitado sa pagpapayo sa kanilang mga kliyente tungkol sa kanilang mga karapatan batay sa konstitusyon.
Madam Chair, I would object to that because precisely the rules of investigations in aid of legislation, that is precisely included. But it is not included in the rules of impeachment. Plus, secondly, lawyers will be allowed, in fact, that will contradict the previous ground rule because the lawyers of respondents are allowed to send questions to the chairman. So if you are preventing them only to advise counsel on their legal rights, that is what is stated in the rules in aid of legislation, then that should fall. Because we have allowed already in the first ground rule that there will be questions on cross-examination to be submitted to the chair. So the counsel is not limited to giving advice on the legal rights, the right to counsel, the right to right against self-incrimination, but really to participate through the chair. So I therefore move that we remove
Madam
the last
Chair,
one.
if I may comment,
The Honorable
please.
Zamora.
Madam Chair, number 8 and number 9 of the ground rules are not inconsistent with each other. Number 8 refers to the right of the parties to submit questions to the chairperson in case, and the chairperson has the right or has the discretion to propound these questions to the
resource
parties.
person.
For number 9, Madam Chair, the statement that the parties and their counsels, the counsels are limited to advising their clients about their rights under the Constitution is actually a very general statement that, yes, we should follow what is stated in the Constitution. So, in fact, it says here, dapat silang sumunod sa wastong kagandahang asal at hindi sila papayagang magsalita o gumawa ng mga interjection maliban kung at hanggang sa sila ay kausapin o kilalanin ng chairperson. So this is in fact a very general statement, Madam Chair. And again, as we are in a preliminary investigation stage, we are not violating the right of the respondent to counsel. In fact, I would like to make it a point that the respondent and his counsel and her counsels are not present. Thank you, Madam Chair.
Thank you. Any other manifestation? We are
Madam
on
Chair.
number 9
Madam Chair.
ground rules of impeachment, of the
Madam
hearing
Chair.
proper. The Honorable Tino.
Madam Chair, this is just a request for copies, even electronic
Yes.
copies of the ground
Yes,
rules.
may we
under
direct the committee
consideration.
secretary to provide the members with a copy of the ground rules?
Madam Chair, manifestation.
The Honorable D.S. Puno.
I refer back to the comment of the chairperson earlier that the questions being raised by the lawyers be coursed through her for determination on whether or not they are germane to the discussion. This leads us, Madam Chair, to the question of what is this committee tasked with deciding? Are we going to decide veracity or non-veracity of evidence? Or are we merely made to decide whether the evidence presented by the complainants are relevant to the complaint that they have submitted? When we forward whatever decision we make to the Senate, do we say that contrary to a preliminary investigation, that there is probable cause? I do not think that that is the obligation of this committee. I believe, Madam Chair, that the obligation of this committee is to verify that the witnesses presented will present testimony that are consistent with the complaints that we have already ruled as of substance and form. So maybe the right to counsel is not properly addressed here because We're not after truth or falsehood of the evidence that's coming in. Merely relevance to the complaint that have been submitted by the complainant. When we elevate it to the Senate, we are not saying that anything is true or not true. We're not saying that anybody is guilty or not guilty. We're merely saying that the complaints have been found to be in form and substance. The witnesses presented have been consistent with the complaints that have been submitted. And that is going to be the substance of the decision that this committee will make, Madam Chair.
Thank you. And in addition to that, let us be reminded that part of the ground rules is allowing the lawyers of the parties, that includes the lawyers of the Vice President, to submit their questions to the chairperson so that the chairperson can raise them to the resource persons or even to the parties in the case or the witnesses, so long as the same is germane to the impeachment proceedings. So with that, may we proceed to rule on the motion? The Honorable Ko and then the Honorable Jokno.
Thank you, Madam Chair. Madam Chair, I would concur with Representative Joel Chua and the current stipulation of the ground rules and find no contradictions, whether it be in the Constitution, in the House rules as we speak, and in the principles of due process that we are providing the respondent as of now. Also to clarify, the process that is on the floor right now is so that this committee, at the end of the succeeding hearings that we will be holding, makita natin kung may probable cause or hindi. Kung mag-proceed, na dapat mag-proceed to a full-blown trial o hindi sa Senado, yung complaints at bar. No? And to that end, isang step beyond sufficiency of substance and yung relevance na laman ng mga complaints, yung dapat i-determine ng mga members of this committee and the committee at the end of the day. That's why, for me, kailangan din po yung hindi lang presence ng respondent, but rather yung meaningful advice that the lawyers can provide, which is sufficiently detailed naman na po doon sa ground rules na pinopropose. So, Madam Chair, if necessary, I would like to second the motion as on the approval of the ground rules.
After the manifestation of the Honorable Jokno.
Thank you, Madam Chair. To ensure consistency and as well avoid the possibility of any litigation that may question the rules of the committee, perhaps the committee could entertain a possible amendment to the proposed House rules. The last provision, to make it clear, could state that the participation of counsel shall be limited, number 1, to assisting their client, number 2, to submitting questions to the chair, and number 3, to filing whatever appropriate manifestations they choose to, and if required by the committee, a memorandum as stated in the rules on impeachment. That way, there can be no issue as to, no one can argue that the right to counsel is being denied by the committee. I would make so move, Madam Chair.
Second.
That is a motion for, if I may be clarified, Honorable Jokno? Because there is a pending motion as well for the approval of this ground rules. So may we hear first, before the second motion, that is for the amendment, if the proponent of that ground rules is accepting your proposed amendment.
Madam Chair, can I just insert this manifestation?
Kindly wait to be recognized, Vice Chair Dumogan.
Madam Chair,
please.
I accept the restating of the ground rules as amended by the Honorable Jokno, and I would like to point out that these are just ground rules and not rules of the House of Representatives. These are just the ground rules of the Committee on Justice.
With the acceptance by the proponent of the amendment by the Honorable Jokno, may I hear the necessary motion to approve the amended ground rules?
So
Vice
moved,
Chair
Ms.
Zamora.
So moved, Madam Chair.
Second, Madam Chair.
There is a motion to approve the amended ground rules by the Honorable Dumogan. It has been seconded. Is there any objection? Hearing none, the amended ground rules is hereby approved. Now we proceed to the next matter. Earlier, the Honorable Redon is manifesting a letter received from Fortune Narvasa Law Office. Now we recognize the Honorable Redon for that matter.
Madam Chair, the counsels of Vice President Sara Duterte, Fortune Narvasa Salazar, and Attorney Michael Wesley Poa submitted a letter explaining the Vice President's absence today and their absence as well as counsels for the Vice President. And I will read the main basis for their objection to attending today. Under these circumstances and considering the public statements made by the chairperson, it appears that the committee intends to conduct a trial. I think, Madam Chair, the House Committee on Justice should confront this accusation squarely today. This particular position of the counsels and of the Vice President herself is basically a legal word salad. Ibig sabihin po, wala po itong batayan sa katotohanan. Ito po ay legal na pagpapalusot para lusutan na naman pong muli ang pagpapanagot sa mga impeachable offenses laban sa atin pong pangalawang Pangulo. Yung pong paggamit ng mini trial ng ilan po sa mga kinatawan ng komite pong ito ay para lamang po sa pagpapaliwanag sa atin pong mga kababayan nung pong pagtakbo ng proseso po na impeachment. Particular, ito pong hearing proper, at more particularly, to make a distinction from the actual trial which will happen at the Senate. No? So, tingin ko yun lang po yung malinaw po na distinction dito po sa bagay po na ito. And Madam Chair, there is nothing in the rules and the proceedings that we have today which can in fact be considered as unconstitutional. I will read for the record the rules yet again and the constitutional provision. The constitutional provision in Article 9, Accountability of Public Officers, Section 3, 2. A verified complaint for impeachment may be filed by any member of the House of Representatives or by a citizen upon a resolution of endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. The committee, after hearing, this hearing, Madam Chair, and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. That is the constitutional provision, Madam Chair. The rules of impeachment of the 20th Congress, Section 7, submission of evidence and memoranda. If the committee finds that sufficient grounds for impeachment exist, the committee shall conduct a hearing. This hearing, Madam Chair. The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. The committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. These are particular provisions which guide the hearing proper today. And therefore, Madam Chair, hearing is mentioned in both the Constitution and the rules. This is the hearing proper that is mentioned in the Constitution and the rules. And part of hearing, any hearing, is the receipt of evidence. Ang sinasabi po ng mga abogado ng pangalawang Pangulo, wala daw pong karapatan ang komite pong ito sa yugtong ito na tumanggap po ng mga ebidensya. Pero alam po natin na sa mga pagdinig, bahagi po ng mga pagdinig ang pagkuha po ng mga ebidensya. Make no mistake, Madam Chair, the committee will fulfill its constitutional mandate to conduct hearings in the context of impeachment. More importantly, make no mistake, we will receive evidence during these hearings. The subpoenas of all the witnesses and documents will be issued. The subpoenas on the audit reports and congressional records will be issued. The subpoenas on the SALNs, on the bank records, on the tax documents, on the businesses, corporate records of the Duterte Carpio couple and their business interests placed in the SALNs of 2024 will be issued. We will fulfill this mandate today, Madam Chair, until the very end of these proceedings. Yun lamang po. Maraming salamat.
Just for the record, the use of mini trial by some members of the Justice Committee is intended only to make a distinction between the proceeding before the Justice Committee and the trial which will happen in the Senate. Let us always be reminded that our parameter in our hearing proper is the determination of probable cause only, which means the justification to be able to proceed to trial. Again, we are not yet determining the guilt. We are not holding trial. This is just a clarificatory hearing for the purpose of determining probable cause, which will allow us to proceed to trial in the Senate.
Madam Chair.
That is for the record. The
Madam
Honorable
Chair.
Ko.
Madam Chair.
Madam Chair, a comment.
The Honorable Ko and then the Honorable D.S. Puno.
Madam Chair, also for the record, there is a statement released by the Office of the Vice President, echoing the parts of the letter issued by counsel, and again using the word quote-unquote mini trial. Madam Chair, on the record, I'd like to contest and express my grievance on the use of the word mini trial. What is happening on the floor, Madam Chair, is determination of probable cause. It is a different proceeding that if you also provide equivalents in how we do this in the judicial proceedings, clear naman po ang distinction ng ginagawa ng Office of the Prosecutor. And kapag nahanap na po yung probable cause na yon, magpo-proceed na po sa trial sa korte. For me, Madam Chair, it is irresponsible to muddy legal concepts so as to create a reason para po hindi mag-appear and even defeat the capabilities of this committee to talk about evidence, pleadings that is provided and may avenue naman na pinapadaloy under our House rules. So, Madam Chair, I'd just like to put on the record yung grievance on the use of the word mini trial. Thank you, Madam Chair.
Thank you. The Honorable D.S. Puno.
Thank you, Madam Chair. I refer back to the comment earlier by Congressman Jokno, which I think is very important, that we try to be sensitive to any actions that the committee takes that might open us to questioning on the higher judicial levels. We are in a hearing today. Hearings usually result in committee reports. Committee reports that will not have a judgment, that will not have any statement on the true veracity of any evidence that is presented here, because that is the work and job of the Senate, in my belief. So the final report that comes out is not a decision, it is not a judgment, it is a committee report that is forwarded to the Senate and recommending a trial. So I believe that the distinction between whether we are having a trial or not should begin there. And that is where we should rest it, not on the dictionary meaning of trial and so on and so forth. So the use of these terms, while sometimes unfortunate, does not result in nullifying the importance of these proceedings. So even the evidence that we review here, we will examine so that we do not send to the Senate meaningless evidence. It must be evidence that is germane to the complaints that have been filed, and it must be evidence that we have verified to be real facts and not just allegations, not just versions of the truth, but something that we all know is actually the truth, because why would we send it to the Senate if we do not believe that that is the case? So I believe that if we clarify this in the course of our proceedings, that we are not judging any testimony, but merely verifying it for purposes of accuracy, relevance to the complaint that has been filed, and so on, and come out with a committee report in that manner, I don't think that this committee can be accused of conducting a trial, Madam Chair.
Madam Chair.
The Honorable De Lima first, and then the Honorable Rodriguez. Rodriguez George.
Yes, Madam Chair, just a brief reaction to the manifestation of the Honorable Representative Puno. Just to be very clear, what will be transmitted to the Senate is not the committee report. What is to be transmitted to the Senate is the articles of impeachment already. The committee report from this committee will be transmitted to the NBank for consideration of the recommendation, for the consideration and approval of the recommendation of this committee, whether probable cause exists or not. So let's just be very clear about it. And Madam Chair, I noticed that the ground rules, the guidelines distributed to us does not yet reflect the amendment. So if we can have, please, the
The
copy
committee
reflecting-
secretary is directed to reflect or include the amendment that was approved already in the approved ground rules.
Thank you.
Are you finished with your manifestation, Honorable De Lima?
Madam Chair, another point. Can we have a confirmation from the committee secretariat that indeed respondent Sara Duterte and her counsels were duly notified of today's proceedings? Second, if so, is there any communication or anything, a pleading, a communication filed or submitted to the committee secretariat saying categorically that they are not appearing in today's hearing or in today's proceedings? And another question is there also any communication or any submission made from their camp explaining the absence of respondent Sara Duterte? Because aside from the letter put on record by the Honorable Terry Ridon about questioning the proceedings under the erroneous premise that what is being conducted here is trial on the merits, there has been statements, pahayag, from Sara Duterte. I think this was circulated already to media. Let me just point out one important statement here. It's a pahayag from the Vice President of the Philippines, Sara Duterte, dated today, March 25. The second to the last paragraph says, "Naisumite ko na ang aking answer ad cautelam. Sa ngayon, wala nang dapat pang gawin ng komite, kundi ibasura ang mga reklamo dahil sa malinaw na kakulangan ng ebidensya." Is this an indication clear enough that she is waiving her right to participate in our proceedings? So I just wish to have that confirmation of the committee secretariat as to whether there's been any formal communication saying that they will not, whether she or by her counsel, will not participate in the proceedings before this committee henceforth.
The committee secretariat is directed to report to the committee the fact of having sent the notice of today's hearing to the respondent, and whether there is a communication or a document filed in relation to that invitation, as well as the same letter which was earlier manifested by the Honorable Ridon. And if there are any other documents received from the respondent, The committee secretariat is likewise directed to report to the committee. Let's begin with the notice sent to the respondent. Comsec, please.
Yes, thank you, Your Honor. The invitation for Vice President Sara Duterte to attend today's initial hearing was sent by electronic mail on March 19, 2026 at 10:25 a.m. It was acknowledged by, it was received March 19, 2026, 12:34 and acknowledged by the Central Records Unit of the Office of the Vice President. The invitation for two Narvasa and Salazar, counsel for Vice President Sara Duterte to attend today's meeting was emailed on March 19, 2026, 10:21 a.m., received March 19, 2026, 1:45 p.m., acknowledged by Fortune Narvasa Salazar. As far as any communication from the Office of the Vice President manifesting that she will not attend today's initial hearing, the only communication we received with respect to that is the letter from her counsel, Fortune Narvasa and Salazar. That's all, Your Honor.
Any comment from the Honorable De Lima?
Thank you, Madam Chair. It's very unfortunate that the respondent herself is disrespecting the proceedings before this committee. At the very least, she should have manifested formally that she will not be appearing before this committee, and rather than just issuing statements before the media. Because that letter submitted by her counsel, the Fortune Law Offices, the law office, is not yet very clear there. Are they appearing or not? Show respect. They cannot just assume that this is going to be a trial, because it's already clarified that it is not full-blown trial. This is not trial on the merits, but simply akin to preliminary investigation. With, of course, right to counsel, right to appear, right to assist the clients, and right to submit clarificatory questions to the Honorable Chair. So this is disrespect, another manifestation of her affront the constitutional process. I remember what the Honorable Chair cited earlier in her opening remarks. There's this quote from former Supreme Court Justice, I think it's Noel Tiham, not Antonio Tiham, as stated earlier, about the fact that failure to appear, failure to participate in the impeachment proceedings, it's itself a betrayal of public trust, because this is a formal constitutional process that everyone is expected to respect, especially the parties like the respondent. So it is very unfortunate that we have this mindset again, this attitude on the part of the respondent, showing disrespect and affront to the constitutional process of impeachment. Thank you.